So I am delighted to introduce Romain Goudjil's first book, Une symphonie des pouvoirs judiciaires à Byzance, donc le rôle de l'Église dans l'administration de la justice. In this monograph, Romain Goudjil attempts to revisit the idea as old as Byzantine studies themselves, dating back to the 18th century, that the church gradually took power over the empire's judicial institutions. By analyzing not only the sources of Byzantine law, but all the legal cases documented in the empire from the 10th to the 15th century, both in the upper strata of Constantinople as for peasants in the remote provinces of the empire, he proposed a new interpretation on this matter. The book first presents an overview of the administration and structure of justice in Byzantium between the 10th till the 15th century, before focusing more specifically on the role and action of the church and clerics of the empire in the justice system. This allows the author to show the continuing role of the church in justice right up till the end of the empire, after it took charge of marriage-related issues from the 12th centuries onward. Civil and ecclesiastical justice work together within the respective spheres of competence, and these 9 chapters show that the emperor and the Byzantine state retained their prerogatives in the administration of justice until the fall of Constantinople in 1453. Finally, I'd like to add that for the first time, the book provides an accessible way of looking at and understanding the Byzantine experience of justice, as well as the violence that could run through society and its means of resolution, thus also offering us a new and essential look at the Byzantine world and opening up the prospect of placing the individual at the center of historical reflection. So, Romain, I think it's better if I let you talk.
First of all, I want to thank Petros, Lucas, and Callum for the organization of this book festival, enabling us to talk about our research to Byzantinists throughout the world. And thank you very much also to Benoit Cantet, who agreed to chair the presentation of my book. I owe you one. I will just share my screen. Are you seeing my screen, the presentation? Or no?
Oui.
Oui, d'accord. So, A Symphony of Judicial Powers in Byzantium is my first monograph based on my doctoral research, which I defended in 2021 in Paris. I began my journey within Byzantine studies by working on documents of the archive of Mount Athos, especially judicial one, and then I get more and more interested in the judges enacting these documents and rulings. I was particularly intrigued by the complex relationship between the monks, the emperor, and the church, and the way all these institutional actors played with the law in their own interests. That is the starting point of this research, which led me into the so-called exotic garden of Byzantine law. As the title suggests, this book aims to give a better understanding of the theory of the Byzantine Symphony of Powers, that is, a relationship between the emperor and the church within the state. The Byzantine Symphony of Powers is loosely defined in Byzantine text, and sometimes the concept is subject to contradictory definitions even today. I try to go beyond the theoretical definitions of this Symphony of Powers to understand how it was legally conceived and implemented in the administration of justice. Since the 18th century, the modern historiography already gave a long-standing narrative pattern to the role played by the church in the judicial affairs. From Montesquieu to the legal historian Mortreuil and Zacharias von Liegenthal all point out that there was an absence of a clear judicial competencies definition attributed to the church or to the emperor. They emphasize the growth of the church, jurisdiction, and powers to the detriment of the emperor. This growth paralleled a hypothetical weakening of the Byzantine emperor due to 1204, the division of the empire, and the civil wars in the 14th century. Thus, the church would have become, from the 14th century onwards, the head of the judicial administration and the patriarch, a real chief justice. Alongside other recent efforts in the scholarship, this book aims to revise this old historiography by looking more carefully to the evidence, especially by comparing the legal framework established by the emperor in the Byzantine written laws and the judicial practice preserved in numerous archives and compilations. I particularly studied the Basilica, its scholias, the educational commentaries written in the Middle Byzantine period, such as the Ecloga Basilicarum, and of course, the other private legal compilation produced until the end of the empire, such as the Xe-XVe. In parallel, I examined the archive of Mantatos, some monastic cartularies, the 13th century's compilation of rulings from Epirus, written by Komatenos and Apokafkos, and of course, the register of the Patriarchate of Constantinople, containing mainly synodal documents from the 14th century. Based on this documentation, these works revolves around three main issues. Did the Church gain new judicial competencies between the 10th and 15th centuries? Were clergy really actors in the exercise of Byzantine justice after 1204? How much autonomy from the imperial administration did the Church have in its judicial activities? In order to answer this question, I described firstly the Byzantine judicial organization and its evolution to understand the means of action of the Church and the clerics within it. One chapter deals specifically with the issue of mixed jurisdiction involving clerical and lay judges, in particular the general judges of the Roman, in order to show that these courts always depended on the imperial authority. Then I examine chapter by chapter every legal field: family law, marriage, succession, issue pertaining to total property, criminal law, sex crimes, murder, magical practices, treason and heresy, ecclesiastical affairs, litigation between bishops, criminal clerics or unsubordinate clerics, monastic affairs, who was the competent judge for the monks, and property and land litigation and the use of arbitration. In each chapter, I compared these cases to the legal framework in order to evaluate the actual role played by the Church and the legal grounds of her authority in courts. This book shows that the Church did not get new judicial competencies after the 11th century. The ecclesiastical justice had an important role in the settlement of civil litigation, especially pertaining to family and matrimonial laws, but the Church played the part the emperor gave her within the legal framework he established. Clerics were deeply involved in the day-to-day of the settlement of litigation between the Byzantines, but rarely beyond the power the emperor entrusted them. They mainly acted as mediators between parties in order to avoid taking actual legal action. In the Byzantine Symphony of Judicial Powers, the Church served the interest of the Byzantine state and of the emperor. Another important point made by this book pertained to the relationship of the Byzantine to their written laws. Indeed, in the 90s, Alexander Kashdan wrote his famous article, "Do We Need a New History of Byzantine Law?" arguing that Byzantine written laws were of little interest for historians studying the Middle and Late Byzantine period, given that these laws were essentially Roman laws and Justinianic laws from the 6th century, translated into Greek with few efforts of adaptation to the medieval time. For Kashdan, written laws were fossilized laws having no link with the actual Byzantine medieval society. In this monograph, I show that the legal framework established in the written laws compiled in the 10th century onwards was actually implemented, especially concerning public laws, judicial competencies, and jurisdiction. Judges, litigants, church, and emperor mainly followed the laws enacted by past emperors. Thus, Byzantine written laws could be a necessary tool for the historian to really enter the everyday life of the Byzantine and not always an abstract text out of touch with the Byzantine medieval reality. Lastly, this research gave me the opportunity of examining almost all the judicial documentation preserved for the Byzantine Empire from the 10th century onwards. I mainly studied these documents from the top, from an institutional and legal point of view, but many questions arose pertaining to the everyday practice of the administration of justice for the judges and the litigant, how the Byzantines really understood their written laws, what was the place of legal compilation manuscripts in court, what was the actual legal procedure but also where took place these judicial courts, who were the staff of these courts, what were the Byzantines looking forward to when they initiated legal proceedings. More generally, I will try to follow this path in order to be able to draw a more accurate picture of the Byzantine experience of justice, not from the perspective of the institution and the state, but from of the Byzantine subjects themselves. You can find here the link to the publishing house website and also a link to the review written by James Morton in the Byzantine Review. Thank you very much for listening to me.
So, does anyone have any question? If not, I will ask you one first. How did you manage to choose when you had to interpret something between the law itself as it's copied in the basilicas or in the ex-libros, and a legal case where you have some differences? I mean, how do you manage to find, I won't say the truth, but the link between law and its application?
I mean, there is a lot of variations between multiple cases. Concerning the competencies, I think that most of the cases are following the law. Concerning the content of the litigations, I mean, for example, a marriage litigation or succession litigations, most of the time it is written in the cases that, I don't know, the ecclesiastical judge know that the law is saying that, but it will apply another solution because of economia, for example. And one tool which is very useful to try to look at the actual Byzantine reality is the use of the commentaries and the scholias of the Basilica. For example, in the scholias of the Basilica from the 12th century gives us a real insight of the understanding of the law by the Byzantines of this time. So it is, yeah, we need to combine all these stuff to trying to find what did they understand of this law, in fact. I'm not sure I answered to your question.
Does anyone have any question? If not, I may have another one. But...
I think there is a question in the.
I don't have anything in the chat.
In the question-réponse.
Ah, pardon. So, what roles did clergymen play in the legal system? You spoke of judges and mediators.
There is ecclesiastical judges. They are working in the synod, the Constantinopolitan synod, or the metropolitan, or the synod of any bishoprics. But there is also a lot of clergymen in villages, for example, who act as mediators, who play the role of arbiters or notaries. So they all play a role in the legal system, but they do not all play a role as a magistrate or judges. That is the difference. Yeah.
Okay, I have two other ones from Theo Marinos. How many of them, so clergymen, were trained lawyers, and how did the rest of them acquire their legal knowledge?
I will say that most of them were not trained lawyers at all. In the 13th century, for example, the Archbishop of Ohrid, Demetrios Komatianos, compiled all his rulings in order to give some example to the other bishops and clerics of Epirus, because he considered they were lacking of any training and they needed to just follow example of real people trained. bishops are trained like all aristocrats are trained. They follow the same level of educations, I mean. So they just acquire their legal knowledge by experience, by judging, but there is no school, law school in Byzantium generally.
Thank you. Does anyone want to add something or intervene? Feel free to take the mic. I will have another question for you, something we have discussed already. What did you think was the influence of the Fourth Crusade and the famous 1204? I mean, is that really a cut in Byzantine legal law, or is it not? I mean, what do you think about that?
I think I try to show that in the book, that there is no real discontinuity. It is not a pivotal date, in fact, for the legal practice. For example, John Apokafkos, the Metropolitan of Naupactos, he was bishop before 1204, and then he was bishop after that, and his practice did not change. And I think that there is a lot of continuity in the legal text. There is no many changes, and there is a lot of continuity in the practical sources, practical documentation we can see. So I don't think that on that topic, 1204 is really an important date to build some kind of distinction between periods.
Thanks. Does anyone want to ask anything? We are still on time. If not, I will hand over the discussion. Thank you, Romain, and I still I think I'm gonna add that I really liked to read it, and thank you again.
Thank you, Benoit, and thank you for all the organizer.